This is a very expensive process. You have to think of Chapter 11 filing like a lawsuit, and things can happen during litigation that are unanticipated. The thrust here is going to be to get your company in, reorganize it quickly, and get it out. Along the way, you almost always are going to have to pay for a creditors committee. You're going to have to pay your secured lenders fees, assuming you have secured lenders. You're going to have to pay the debtor's fee. Each of the debtor, the committee, and the secured lenders are going to have financial advisors, maybe investment bankers. All that's going to cost a lot of money.
So I have to have a lot of money to go broke.
You got to have a lot of money to go broke. And the way you minimize that expense, if in fact you need bankruptcy, because that's the next thing that I talk to them about. So, first I want them to understand that this is not something to be undertaken lightly.
The year was 1978. A new bankruptcy code hit the books, and suddenly, the playbook for American business failure was rewritten. 47 years later, we're still living in its shadow. My guest today, well, he's been around since the beginning. John Melko, a seasoned restructuring attorney and partner at Foley, has watched the system and watched the bankruptcy courts evolve from its reformist roots to the high-stakes, high-cost beast it is today. Together, we're unpacking the rise of Chapter 11, perhaps its fall, the industries it's failed, and the billion-dollar burn rate it now takes just to go broke. This isn't theory. It's the hard truth behind corporate collapse and what comes next.
Drew, thanks for the introduction. Good to be here. A pleasure to be your inaugural guest, even if you did make me a few years older than I really am. So what do you want to talk about?
Well, we're going to talk about Chapter 11, but a little bit about how you and I met. John and I met probably 30 years ago when he was at what essentially was the birthplace of bankruptcy lawyers in Houston, a firm by the name of Scheinfeld, Maley & Kay. And John and I met each other, in the 80s?
Yeah, now you're making us younger. But
we're making us by every minute.
He's bad at math.
It's true. But John and I met, but we didn't know each other until I started my firm, the McManigal Company, which is a very original name, in 1992. And then we worked together on the El Paso refinery case quite closely and got to be good friends after that.
Yeah, that went on for a number of years. Interesting case. So do you want to start talking about how things changed from the Act to the Code?
Yeah, I think that'd be a good place to start because the Chapter 11 isn't exactly what it used to be. So where did we start?
Well, it's changed quite a bit. So I started practicing law in 1984. The Bankruptcy Reform Act was passed in 78, became effective in 79. Yep. Before that, you had Chapter Roman numeral 10, Chapter Roman numeral 11 under the old Act. There were still some of those Act cases that were pending when I started, but I didn't work on any of them. It's interesting, though, we see concepts from old Chapter Roman numeral 10 and 11 that were carried forward into the Code. A lot of the case law from those old Act cases remains good case law. Perfect example is everybody who practices bankruptcy law knows that bankruptcy law looks to the state law in which the property is located for determination. Well, that was a Supreme Court case, Butner versus the IRS, out of the 1970s. We'll talk about jurisdiction in a minute, but everybody knows about the Stern v. Marshall case and what it did to bankruptcy jurisdiction, that in the initial opinion that private rights versus public rights is really not a new concept. And in fact, that was discussed in the Marathon Pipeline case. So let's take a step back. Congress determined sometime during the 1970s, as a result of the Bankruptcy Review Commission and what have you, that there were problems with the old Bankruptcy Act. So it enacted the Bankruptcy Code.
What were those problems, John?
Well, a number of things. Under Roman numeral 10, which was a corporate reorganization chapter, you had the automatic appointment of a trustee.
Oh.
At least if the case had more than $250,000 and I think it was public debt. Chapter 11 was the Roman numeral 11. The title of it was actually arrangements.
Oh, I remember that.
Yeah, and that was more geared toward kind of the more modern plan of reorganization process that we have now. So essentially what Congress did, in part it was done to try to get away from some of the perceived abuses and inefficiencies, because having one or more trustees, which is what the old act provided, was very inefficient. Yeah. There are some other problems too, but they kind of melded Roman numeral 10 and Roman numeral 11, came up with modern day Chapter 11. It did away with the automatic appointment of trustees so that debtor's management would become the debtor in possession unless somebody moved for the appointment of a trustee or an examiner and could show, quote unquote, good cause why the court should grant it. One of the other things that it did was it provided for the automatic imposition of what we call the automatic stay, or an injunction that arises. Nobody has to ask for it. It just happens when you file a bankruptcy petition.
Which is one reason a lot of firms who have a lot of litigation outstanding, they may be financially fine, but they'll file Chapter 11, just impose automatic stay in case a judgment is getting ready to get entered, or perhaps right before trial or another adverse action, right?
That's true. And another interesting difference between the old act and the code was under the act, both under Roman 10 and Roman 11, the debtor had to state that it was insolvent. It couldn't meet its obligations. And the court, certainly under Roman 10, not positive about 11, would actually have to grant the petition based on a finding that the debtor was insolvent and needed help. That's not the case now. And the Third Circuit opinion, and we're jumping way ahead in the chronology here, but you had the Johnson & Johnson case dismissed twice in the Third Circuit because the court found, well, the company wasn't insolvent. And it wasn't Johnson & Johnson. It was its special purpose vehicle. Yeah, it was the so-called divisive merger, or Texas two-step, to put the liabilities in a separate company. There's no requirement in the bankruptcy code. And the Third Circuit's sort of out on its own here that says you have to have a finding of quote-unquote insolvency. As you know, insolvency is a very broad area.
And it's hard to prove sometimes.
And where you have thousands of pending cases with a possibility of runaway juries or what have you, there's a good argument that the company simply has more problems than it can say grace over, even if on a balance sheet basis today it's not technically insolvent.
But as I recall, the old act, which I never worked under either, was focused more on liquidating companies than rehabilitating companies. And then when new Chapter 11 came in, it really focused on, at least initially, on giving companies that had some type of financial or operational problem some breathing room, hence the automatic stay, hence some of the other provisions in the new Chapter 11, to give them a chance to rehabilitate themselves within the context of a Chapter 11, to get a plan done or to sell off some assets, to rejigger their business, if you will, under the bankruptcy code.
So keep in mind that old chapter Roman numeral 11 was titled Arrangements. That was actually the title of that section of the Bankruptcy Act. And that was more geared toward trying to confirm some sort of plan. Now, differences between the two were, at least as I recall, in Roman numeral 10, you did get an automatic stay. I think in Roman numeral 11, I hope I don't have these reversed, you actually had to file a petition asking for it. Kind of makes sense if I'm correct about that, because in 10, the court would automatically appoint a trustee. So, having an automatic stay would give that trustee some breathing room to figure out what he or she had. Yep. Under 11, where management remained in place, the company would actually have to ask for the automatic stay, but it was supposed to be doing this while it had a quote-unquote plan of arrangement in effect. Another big difference between the act and the code was under the old act, you didn't have Article 1 judges. You had referees who were sort of an administrative agent.
That's right. I forgot about
even
that.
though everybody called them judge and what have you. Under Chapter 11, you had the article. They were still not Article 3 judges, the constitutional judges, but they were
like
appointed
a district judge.
Like
a district judge is an Article 3 judge.
That's correct. An Article 1 judge is sort of like a tax court judge.
Right.
It's an administrative post. They are clothed with a lot of the responsibilities and powers of being a judge, but there are certain things that they are prohibited by statute or prescribed in their jurisdiction from doing. And that distinction became both clear and very important early on in the history of the bankruptcy code. You had the Northern Pipeline versus Marathon case, where it went all the way up to the Supreme Court, and it was Justice Brennan said, you can't have what he would think of as a referee, a non-judicial judge, not an Article 3 judge, making these decisions governing public rights. And that created an uproar. Now, that opinion, I think, was in the very early 80s, maybe 82, right before I started practicing. They delayed the imposition of essentially finding that big chunks of the bankruptcy code were unconstitutional to give Congress a chance to fix the statute. Congress being Congress, they didn't fix the statute. So then the Judicial Conference came up with some rules which ultimately became statutes or engrafted into statutes, creating the core versus non-core. So for core matters, C-O-R-E, these are things that are kind of the meat and potatoes of the bankruptcy practice. Right. The bankruptcy court can fully adjudicate those.
So let me ask you a question. With that background, and you've been practicing for a long time, and I have a $100 million company. I'm the CEO. We had some product liability issues. Our cash flow isn't bad. I come in to see you. I get referred to you, and I come in to see you. What are you going to tell me that Chapter 11 is going to do for me?
Well, it's going to cost a lot of money first, and that sounds funny, but I tell people right up front, this is a very expensive process. You have to think of a Chapter 11 filing like a lawsuit, and things can happen during litigation that are unanticipated. The thrust here is going to be to get your company in, reorganize it quickly, and get it out. Along the way, you almost always are going to have to pay for a creditors committee. You're going to have to pay your secured lenders fees, assuming you have secured lenders. You're going to have to pay the debtors fees. Each of the debtor, the committee, and the secured lenders are going to have financial advisors, maybe investment bankers. All that's going to cost a lot of money.
So I have to have a lot of money to go broke.
You got to have a lot of money to go broke. And the way you minimize that expense, if in fact you need bankruptcy, because that's the next thing that I talk to them about. So, first I want them to understand that this is not something to be undertaken lightly. Second, I want to talk about whether you really need to file. Like, what problems are you facing that you need the relief of the bankruptcy code and the bankruptcy court for? And we'll talk about with the client, what sorts of relief can they get?
Do you think that's changed over the 40 years that you've been practicing, that I've been working in this business? Because it seems to me there's a lot less, everybody's read about prepackaged plans that have been negotiated between the secured lenders and the different tranches of debt underneath and bondholders, et cetera. But has the focus on trying to actually fix the business within a Chapter 11 proceeding, has that changed? I mean, is that just old school thinking?
Well, the answer is yes, and the continued answer is, but it should not be. You also have to try to impress upon a prospective debtor client that the more that they have negotiated or arranged outside of bankruptcy, the shorter the process is going to probably be, and the better off they're going to be. Now, there's been a lot of changes. Let's forget about the changes in the law and the statutory changes, jurisdictional, trimming around the edges, et cetera. There have been seismic changes in the way bankruptcy cases are approached from what you're talking about to the way they are now.
Yeah.
And by that, and that's a very complicated story, but let's start with who the lenders are. When you and I started, the secured lenders almost always was a bank group.
Yep.
Okay. And banks back in those days used to be in the business of collecting deposits, making loans, and getting repaid on those loans.
And bad clients went into the workout group which was a section inside the bank, and those guys were always pretty hard-assed about trying to get their money back for their clients.
Well, that's exactly right. And so not everything, but most things tended to be very difficult in a fight with the banks.
Yeah.
But the bank's main objective was getting their money back. And if the bank...
Shocking, right, for a lender?
Yeah, sure. But if the bank understood, or the banker understood, that this company was worth much more alive than dead, they would work with you. So you would go into the bankruptcy case and you would fight with the bank very often, hopefully come up with a deal on the use of cash collateral, the cash that was being generated by the bank's collateral. And that's how you ran the company.
And the debtor's business.
And the debtor's business, yeah,
Right.
because the debtor in possession would remain manufacturing widgets or providing services or whatever, drilling wells or whatever it did, right? So you've got the ongoing business. It's hopefully got some contribution to cash flow. And then you have the rundown of the accounts receivable, which hopefully you're replenishing. And that's how the business would operate. And the bank would get replacement liens on the new receivables that were being generated by running the business. That lending model has changed. And, I blame Dodd-Frank for a lot of it after the banking changes. It is.
And that was after the financial crisis in 2008, right?
Yeah. So banks are under so much regulatory pressure right now
Yeah.
that they would much prefer to simply be the agent of a loan, to where they'll collect agency fees. They'll have some of their own money at risk in the loan. But what we find now is the private credit market, the debt, the bond market, hedge funds, private equity funds, debt funds, entities like that are providing more and more commercial credit, certainly for the larger companies. The smaller companies are going more and more to factoring, merchant credit advances,
Asset-based lenders.
Asset-based lenders.
Yep.
They don't have a long-term interest in seeing a customer survive like the old bank did. They don't much care, right?
Yeah, because in the old bank, you might have a relationship with bankers for decades. I know in my family's oil well servicing business, we knew an old American Bank of Commerce, those guys for like 20 years, 30 years. And they wanted that continuous stream of business.
Right. And, often that relationship changed pretty dramatically if the company defaulted, but putting that aside,
Right.
If the company can demonstrate to that bank that it was going to be able to come out of this and resume their role as a good customer,
Yep.
the bank was interested in doing that. With the new funds, first, a lot of these new funds, you've heard the term loan to own. Well, let's just sort of put that to the side. There are some occasions of predatory lending or a hedge fund or private equity fund will want to take over a company. I don't see that often. What I see more often is a fund or a group of funds that may have other portfolio companies in the business. So they feel like they can contribute some insight to the business. And if the business fails, there are worse things because they can fold it into one of their portfolio companies. Yeah. There is less emphasis on reorganizing that company. And I think that's one of the reasons, Drew, that we see the failure rate on Chapter 11 has always been high. My guess is that it remains pretty high. It may have gotten a little better. I don't have the statistics to back it up and I think if I did, the success rate would have to be discounted a bit to distinguish between true reorgs and reorganizations, which are really 363 sales with a confirmed plan, which gives avoidance actions or something like that to the unsecured creditors.
Yeah, and it's pretty interesting too about that because you talk about failed Chapter 11s, and people hear about Chapter 22s. Well, what is that? Well, it just means that a company went through Chapter 11. 1 or 2 years later, they didn't fix the business. 9 times out of 10, what we find is they fix the balance sheet, but they didn't actually fix the business, or they failed at trying to fix the business. And so they file another Chapter 11. There are some notable examples just recently that where companies had just filed Chapter 11 a couple of years ago,
Right.
and then they go back in.
Yeah.
One of the things that we do in our practice is after, we have the initial conference and we start doing the assessment, we have an internal conversation asking from the marketplace, is there a reason for this company even to exist? I mean, in this market, in its niche, whatever that
Right.
is, whether it's
Yeah.
oil and gas or retail or food prep, whatever it is there a reason for this business to exist? Because if there's not, it really does change your viewpoint about what you should be doing. Because why are you going to spend $5, $10, $15, $20 million on a business that really doesn't have a support base?
No, I agree with that. Although I want to take a step back on the Chapter 22s, I think you're right. People are less focused on fixing the business and more focused on getting a confirmable balance sheet. But where I'm going to take issue with you is I don't know that means they've really fixed the balance sheet.
Yeah.
What it
I
means
think
to
that's
me,
probably right.
yeah, what it means to me is that their financial advisor or their investment banker came up with a set of projections with company management, which, we talk about best case, worst case, middle case.
Yeah.
A lot of times I see these things based on best case, and management is supremely confident that all these things are going to fall in line.
Management is always supremely confident right until they're not.
Well, I think it was Judge Edith Jones that said denial's not just a river in Egypt.
Yeah.
The debtor's euphoria syndrome, something good is always going to happen. That continues. And I think a lot of times coming out of a bankruptcy case, the company will be overconfident in its ability, having gotten debt relief, having hopefully right-sized its contracts, things of that nature. I mean, there's a case for it, certainly. They're not making this up out of whole cloth, but I think in a lot of instances they're over-optimistic on the debtor side. Then on the lender side, so the funds will end up usually converting a big slug of debt to equity, right?
Yeah.
And for that, they'll expect a pretty healthy return. That may or may not materialize, but during the interim, they get a pretty healthy return on the amount of debt that they left on the company. And they can show their investors that, look, we're getting monthly cash flow. This is all working according to plan. I think in many instances, they simply leave too much debt on the company.
Yeah.
So I think
And
that's one of the reasons you get a Chapter 22.
Well, and especially in private equity deals, where the private equity company buys company A, puts in X millions, tens of millions, hundreds of millions of dollars, gets a coupon or return on that,
Yeah.
runs the business, and as long as they're getting their cash or cash flow back, they don't really care what they're doing. And I don't think,
Well, they do because, they've got sort of sunset horizons.
well, true.
Yeah, on their funds. And what they're hoping to do is demonstrate an earning track record. So like, let's just say it's an 8-year private equity fund, right? So the partnership that's invested in that instrument.
Those 8 years.
Yeah. Well, it doesn't turn into a pumpkin after 8 years, but they're hoping to get cashed out after 8
Right.
years. And if there's too much debt on the company, or it's just sort of bumping along without really generating outsized returns such that you can market it, that's what gives rise to these zombie funds that we've all heard about.
Right. Do you think management of these companies ever have an inkling of what they're getting into in a Chapter 11 or in a restructuring like that?
I think a lot of them who have not been through it before will tell you they didn't really understand what they were signing on to before they signed on.
Yeah.
At this point in the cycle, we see some veterans that have been through it before. And certainly where a lender or an equity owner that's maybe a fund has experience with restructuring, they will try to either have some new management hired that's got turnaround experience, or put somebody on the board that's been through this drill before to try to insert some sense of reality about the process.
The favorite thing, I always makes me either want to smile or throw up my lunch, and it's always a 50-50 deal with me depending on the company, is these management packages, titled retention packages or key retention packages or whatever they are.
Management incentive programs.
Yeah, management incentive programs. So the same folks who tank the company, and let's just, broadly say tank the company, so it's in a Chapter 11, now get, $5, $10, $15, $20 million retention packages to stay on during the Chapter 11 process. And then at the end of the process, if it's successful or even reasonably successful, everybody gets a big payday and goes home. And I keep asking myself, where do I sign up for that?
I think I can effectively mismanage a company as well as anybody. But
I suspect you and I both could if they just give us one to give us a shot at it.
Yeah. But, I think in fairness, the management incentive programs are really a function of they're a function of negotiations, but we're talking about the justifications. If you have a badly managed company, clearly that management doesn't deserve to be bonused. They may, if there's no one willing to step in, you might need to incentivize that team to stay. That's assuming they've got other options. Nobody really looks at that very closely because they're terrified if the crew walks off.
Well, and don't forget the management company hired the lawyers who are representing them in the Chapter 11. So nobody wants to upset that apple cart.
To fire their client.
Exactly.
Yeah, I think that's right. But let's talk about why the company got in trouble. You can have a company that's well run, that's in a business or in a line of business that's reasonably profitable. They may have, to your point, a market niche or some sort of unique product, and they can get hit with out of the blue a liability judgment, or there can be imposition of tariffs. There could be a tax law change. I mean, the solar companies were in demand, 6 months ago.
Yeah.
And now with, it looks like there's going to be a lot of pork left in the barrel, but with a lot of the tax incentives going away for renewable energy, those companies are suddenly a lot less desirable. It's an expensive proposition. And so they may have some trouble going forward. I mean, we saw the Sonova bankruptcy filed here
just recently.
It's a multi-billion-dollar case.
Yeah.
So I think it's a question of why the company got into trouble. It may not be management's fault, but harking back to something else you said, if there has been some sort of organic shift in the market or in the law or in tariffs or what have you that now make that business proposition questionable, then maybe you should be looking at a liquidation as opposed to a reorg
or a sale to somebody else.
Well, yeah, and so when I say liquidation,
who might manage it more effectively, the assets more effectively,
or it was in a similar business, and it's not that big a stretch to fold these additional assets in.
Yep.
And I don't like the term, but you get the so-called synergy of combining assets into an existing platform.
So let me ask you a question. So this is where we are today, and we could talk about the asbestos cases forever, and the opioid cases forever, and the Johnson & Johnson cases forever. But where does all this lead us currently? And so there's kind of two questions, John. And you have a tremendously successful firm at Foley, that's worldwide and has you've got a lot of bankruptcy partners who are extremely talented besides yourself. What segments do you think are going to be the most problematic in the next year or two? And how do you think we're going to go about trying to solve some of those problems, recognizing that there's just some industries that have fundamentally changed? I mean, retail has fundamentally changed. Right. Fast food, casual dining is fundamentally changed. And a lot of these, depend on the consumer. And the consumer, is making a decision every single day, where are we putting our money? It's like when you and I go to dinner, we're going to go here or here, but it's not necessarily a question of dollar. Who's got the best wine list at the best price?
again, that's sort of a wide array. So in the consumer markets, those can be very fickle. Fashions can change if you're talking about soft goods. The internet has killed a lot of those retail businesses. Yeah. But the stores, I think the retail stores that will continue will have a big internet presence. So you saw the Neiman Marcus reorganization. They're emphasizing, all the retailers that are successful are emphasizing their.
And how could Neiman Marcus go broke with the prices that they charge? I mean, that's always kind of interesting.
Well, it depends on the debt and
right.
What have you, but and also their product mix changed.
Right.
So I think, in my view, listening to what my wife says, that's a company that lost the view of what its customers wanted. Through the various mergers and acquisitions it went through.
Yeah.
It became somewhat commoditized with sort of the less prestigious brands that shared ownership.
Yeah, it wasn't special anymore.
Yeah. So, and I think it's now trying to revert back. So consumer taste can change. And if that happens, there may not be an ongoing role for that business. In the restaurant business, again, the economy on some levels looks very good. On other levels, it looks stressed. Prices are high across the board. They've had labor problems. They've had, I say labor problems, they've had dramatically increased cost of labor. They've had dramatically increased cost of food. I think the food expense is coming down a little bit. Labor has remained high. So what does that mean? It means they have to come up with a way of operating and a menu pricing that delivers value to the consumer in a package that the consumer will want to eat, right? And there are some chains that are doing very well, but a lot of the ones that were sort of Me Too's are not. So, you look at TGI Friday, which is coming out of bankruptcy with kind of new, old ownership, a revamped menu. They're bringing back some items that they had dropped before that were very popular. So, we'll see what happens, but they may do well. There are others that are just one more in the pack.
It fascinates me every time I fly into Hobby and I'm taking Uber to the apartment. There's a Bennigan's.
Yeah.
Right on the side of 59. And it has been closed for at least 35 years. And it just keeps deteriorating. I think I actually ate there once, maybe in the 80s.
Yeah.
As I was going to the airport, and then the whole chain closed. And I've just been fascinated that it's just sitting there and nobody's bought the land or anything else, and it just continues to degrade. But, that's happened to a lot of, chain restaurants.
Well, so a big part of that business is the real estate play.
Yeah.
And demographics change, traffic patterns change. Real estate becomes more or less valuable. It becomes more or less accessible.
Yeah.
And that could put a branch or a position in trouble, as opposed to putting the whole chain in trouble. I think the chains that find the combination of menu pricing, good quality food, good locations, and an attractive, comfortable setting will continue to do well with the customer base. You're going to have a stratification. You're going to have the McDonald's, which will probably also always be fine. I think a lot of it is in the sort of mid-price casual dining that we see a lot of the damage, because I think, here in Houston, Vic and Anthony's will be just fine.
Right.
And I think Mickey D's will be just fine.
Right. It's
the people in the middle that are feeling the stress.
Well, how many, like Hooters has gone bankrupt? I mean, how many nights out of a week can you go to Hooters and have wings and cold beer, other than the obvious?
One of my partners is debtors counsel, so I probably shouldn't talk about
well, I didn't know
that case. Yeah. But yeah, so I think it's sort of the what they call the fast casual.
Yeah.
That's being pressed.
So let's pivot for just a second. One of the things that is interesting that people have been hearing about and reading about, I think, is venue. And venue means where you file a case. whether it's in the Southern District of Texas or Delaware or New York or California or wherever, it's not so dependent. And I think this is one of the things that confuses people. It's not necessarily so dependent on where the company actually conducts operations, although that's a factor, but it's not the only factor when considering venue. So why don't we talk a little bit about that? What's going on in the venue game?
Sure. And, the law professors that write about this will tell you it is a game, but let's talk a little bit more about what it is. So under the bankruptcy code, you can file bankruptcy where you're incorporated or where your principal place of business is and your principal assets are. The bankruptcy petition that has to be signed under penalty of perjury says you've had the majority of your assets in this district for, so long. But there's also the affiliate filing rule, which means if you're headquartered in New York City, but you have a subsidiary in Rapid City, Iowa, and you like the judge there. I just made that up. I have no idea who sits in Rapid City, Iowa. But let's say you like the judge in Rapid City, Iowa. You may want to have that affiliate that's headquartered in Rapid City, Iowa, file first, and then use that as a basis to file the other companies. People have been selecting venue pretty much as long as I've been practicing. Yeah. It was never as widespread as it is now.
Or obvious.
So and if you research the venue statutes and the cases under the statutes, you see they go back a long time. One of the relatively early and notable cases was the Eastern Airline case. Eastern Airlines was headquartered in Miami. It had its headquarters in Miami. It had its main operations there, its maintenance operations, you name it, it was in Miami. They had so infuriated their pilots and some of their other groups that they did not want to be in Miami, trade creditors, pilots, et cetera. So they had, their airline club, which was called the Ionosphere Club.
Right. I've forgotten that.
And that was always a division. It was never a separate company. So they incorporated, they spun Ionosphere, the division, off into a newly formed corporation, Ionosphere Clubs, Inc., or something like that, in New York, state of New York. And then they filed a petition in New York City. Enron did sort of a similar thing, but without even those machinations. It didn't even pretend that it had a subsidiary there, at least that I recall. But in the Ionosphere Club, which is cited in all the venue cases, Ionosphere was headquartered in New York, incorporated in the state of New York. It was a valid place for that subsidiary to file. And based on the affiliate filing rule, they then filed Eastern Airlines in New York City. And the creditor body was infuriated. And they wanted venue transferred to Miami.
Because trade creditors typically exist. I mean, there's an exception.
Yeah, airlines
but they typically where the majority of them are typically where the company is located.
That's right.
Which means everybody's got to get on a plane, or their counsel has got to get on a plane and go to New York for every single hearing if they want to be represented.
Yeah, and the counter argument is,
which is expensive.
It's expensive, but all of our lenders, all of our money center affiliates or lenders or parties in interest are in New York. The lawyers the company chose were in New York. There's nowhere in the code that says convenience lawyers is supposed to come into play, by the way. And you have to remember that bankruptcy judges are people, and they'd much rather work on a big, juicy, interesting case than a Chapter 13.
Yeah.
Not to say those can't be interesting. So you had to go to the judge in New York who had this case and who had started working on it and had entered a cash collateral order and what have you.
Was that Burt Lifflin?
I think it was Judge Lifflin. And tell the chief judge, Judge Lifflin, who did not suffer from a lack of confidence.
No, he did not. I was before him once, and that was plenty.
Yeah, that he was not the right judge for this case. One of my partners was in front of him on something else in Eastern, and one of the things being tried was a claim objection. And the claimant wanted the venue of the claim objection transferred. And as it was reported to me, I wasn't there at the time, Judge Liflin made a comment like, well, New York City is the financial capital of the United States. The bankruptcy court is the financial court of New York City. And I am the chief judge of the bankruptcy court in New York City. He said everything, but I'm the king of the world.
Yeah, exactly.
So, needless to say, he did
God
not.
rest his soul.
Did not transfer venue.
Yeah.
So, you always had some venue maneuvering going on. What we didn't have were judges in competition.
Well, that's where I was going to go next, because they actually are, and it's pretty obvious.
Yeah, it's obvious to all the academics who write on it. The judges will tell you, not unfairly, that they believe that they ought to have a good venue for companies that are proper filers in their court, to where they can get their case adjudicated on a timely basis. Really, in the Southern District of Texas, the original complex procedures,
And that was a new thing, the complex procedures.
right? Those really started under now retired and now a partner at Norton Rose Fulbright, Bill Greendyke.
Yeah.
Because we saw Enron and other cases that should have been filed in a lot of the other oil company cases being filed in either New York or Delaware. Those courts, New York and Delaware, had reputations for having very sophisticated judges and a lot of lawyers who knew the process quite well. So it wasn't crazy that companies would look for a reason to file there or look for a basis to file there.
Because the lawyers in Houston are just as good as the guys in New York.
Well,
the New York guys will never actually say those words, but it is true.
Well, Houston in Texas had been the venue of many large cases. You had Braniff in Dallas.
Right.
You had the Commonwealth Oil and Refining case in San Antonio. Those cases, for the most part, were staffed by.
And what was the airline you worked on?
Well, there was half a dozen of them, but of course, Scheinfeld was co-counsel in the Continental Airlines first bankruptcy. We were special counsel on conflicts for the trustee in Eastern Airlines. I represented British Aerospace and the Conquest Airlines. We did actually 3 out-of-court reorganizations for Northwest before it filed 10 years later.
Well,
we worked on a bunch of airline cases. But the Southern District of Texas felt like it had a lot of big companies headquartered here, that there was really no reason, or should be no reason, for those companies to have to look elsewhere to file. The judges were open enough to understand that there were some problems with the way things were done in Houston that would discourage big companies from filing here. So they came up with a streamlined set of procedures. And of I think 5 judges who were on the bench at the time, I think maybe 2 of them declared they did not want to be on the panel that would handle the cases. So you had, I think, 3 originally good judges who would handle the complex cases, and it worked quite well. Then over time,
because it was more efficient.
It was more efficient. When I started, Drew, I remember, and I started kind of during the crash.
Right. No. Yeah.
The oil crash of the early 80s.
Right.
And I remember walking into Judge Wheelis's court, who's been retired for years, on what was called lift stay day. So all the preliminary hearings on motions for relief from stay would be set on the same day. It was so bad that there was a sign-in sheet outside the courtroom posted on the wall, and you literally had to sign your name on it. And we were set for a 9 a.m. hearing. We got there at like 8:30 or 8:45. I signed in as number 204.
Wow.
And literally, so there were 200 cases ahead of me, and there were more cases set, right? But for 9 a.m. And you might sit there for 6 hours before you got to stand up in front of the judge. And, look, clients don't like paying for that. And if you have a witness or a client with you, that's costing them time, it's costing them money. It is an incredibly inefficient process. So one of the things the complex procedures did was to improve scheduling. And then, of course, when things started getting computerized and, self-docketing and things of that nature.
Oh, yeah, that.
I mean, it was like getting an appointment that is better than going to the doctor, right?
Well, and as the only non-lawyer at Harry Perrin's old firm, Maddox, Perrin and Kirkendall, which was a boutique, successful boutique, I'd go spend hours at the courthouse.
Right.
Because to look at the docket or to look at pleadings, you had to literally go to the courthouse, get the clerk to pull the docket for you, and then she'd bring the files out. And if it was a bigger case, tens, hundreds, of files filled with pleadings that you'd have to sit there and read through.
Well, so that's a different, that's not related to the complex procedures.
No. But I'm just saying back in the old days.
Yeah, that had to do with the electronic filing system, thank God, coming in to where you can look things up online. And that predated even the claims agents.
Yeah, no, that was way back when there were still dinosaurs roaming the earth down in Houston.
Yeah, but it was incredible. You'd have to, as you say, you'd have to go to the clerk's office, stand at the desk, wait in line, ask the clerk for, the file for the XYZ case, stand there at the counter and look at it. And if you wanted a copy of something, the government copy machine would gladly make you all the copies for 25 cents a page.
Exactly right.
So you had to go down there it was like going to the casino or something.
That's right.
It's retirees to get the rolls of quarters.
Because you always knew who was going to win that game.
Yeah, you had to go down there with rolls of quarters to feed the copy machine if you wanted a copy of something.
Well, here we are in 2025, and it's interesting, and you and I talk about this, a lot. But one of the things that has struck me, and I think struck a lot of us who've been in this business for a long time, is, as we talked about earlier in our conversation, is the cost. I read a study, and I can't remember if it was bankruptcydata.com or who did it, but they took a look at the 10 or 12 largest cases that have been filed over the last couple of years. And they looked at all the professionals' fee applications and the partners and associates and librarians and clerks and paraprofessionals' rates and all that. And they blended all of it. And their conclusion was, in these largest cases, that the average billing rate in the large cases was $1,695 an hour. Some partners, at big firms were charging $2,000, $2,500 an hour. And then it dropped down, from there for third-year associates, second-year associates. And it's not that much different in the financial advisory world where we live, depending on what market you're in. Now, obviously, the guys at the really big firms are more expensive than the guys in the middle market firm. But that's a hell of an hourly rate.
Mm-hmm.
We've all talked about it for years. Have the law firms and the bankruptcy lawyers helped to kill the golden goose?
A little bit. And I know a large number of people who have left big firms, started their own boutiques, and have virtually no overhead compared to what like my firm has, or Kirkland & Ellis has, or Weil Gotshal has. The training programs, what have you, those are all wonderful for associates. They are very expensive. And in order to support those, you need rates like that. That's not the only way you can train people. It's certainly not the way I was trained, because, again, starting in what was really a boutique, we got a lot of on-the-job training.
Yep.
We did get to go to seminars, but nothing like what's done now. But you're right. The cost of the hourly rate cost and the number of lawyers that are put on things has gotten very high. It is prohibitive for some clients. I mean, I've had to turn a number of small businesses away or refer them elsewhere that I thought would have been good candidates for Chapter 11, good clients, and hopefully they did well with where I sent them. But it was just something where, and I don't like wasting people's time.
Yeah,
I'll give them my initial reactions. But there have been a number of people I've said, I understand your problem. Here's what I think you should do. You can't afford me.
Yep. It's interesting to me. because one of my colleagues is working on a fairly notable case as a liquidating trustee, and they were looking at fees, and I won't say the name to protect the guilty. And I always think I've seen everything in this business, right? And then you get surprised, and you're thinking, well, how did that just happen? But they were looking at folks' fees, and on this fairly notable case, there were 52 lawyers, not just bankruptcy lawyers, but 52 separate lawyers, partners, librarians, and paraprofessionals that had entered hours on this fairly notable Chapter 11 to the tens of millions of dollars in fees. And, some of them would sit on phone calls. Some of them were finance guys. Some of them were corporate guys, and there's an argument to be made, you need lawyers with some speciality. But I think the other argument is made you don't need them all the time.
Well, so in the real big cases, you're going to have securities issues, you're going to have tax issues, you're going to have regulatory issues, you're going to need a lot of different disciplines. But I agree with you. I've been in depositions where there have been 8 lawyers from the same firm sitting there.
Wow.
And, it used to be that people would actually look at each other's fee applications. I almost never see that anymore. Everybody is sort of relying on the U.S. trustee to do the work. By the way, it costs money to review a fee application.
Sure it does.
Everybody relies on the U.S. trustee. I was on a phone call with the U.S. trustee attorney today on a very simple matter, and he explained to me that, we've had budget cuts. We've had to let some people go in the office. And, my off-the-cuff response, and it wasn't like I was looking for a favor from this guy, was, I thought you needed more people.
Yeah.
Because I see them barely saying grace over what they have.
Talking about Judge Liflin, I was a Chapter 11 trustee in a nasty little chapter, case at, near the middle of my career, and up in New York in front of him, talking about fee apps. So I was used to working here in Houston. And so, the case was over, and I filed my final fee app, and I spent, a fair amount of time preparing for the hearing because I thought I was going to get questioned over all the things I did and why I did them and how I did them and why did you bill that much and why did you take that position and blah, 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 just to justify the fee application, right? So I go into court and I'm ready, I'm ready to go. And Judge Liflin sits up there and he says, okay, we're calling the trustee's fee application in Phoenix Pharmaceutical. Does the U.S. trustee have any objections? No objection, Your Honor. Is there anyone else here in the court who has any objections? Hearing none, I've reviewed the fee application. It's approved. Just like that. Mm-hmm. And I sat there dumbstruck.
Well, you were probably a rounding error compared to some of the other.
I suspect that probably was that was probably the case too. But still, I don't remember in the Southern District there being too many rounding errors.
No. Well, now with the cases that we've been getting, because this has become for a while, and it may still be the case. We were getting more than our share of the mega cases, the over $1 billion cases, right, which were filing in the Southern District of Texas. I think New York and I think Delaware and New York were second and third. Given some of the notable problems recently, that gap is closed. Yeah. But we're still getting very large filings here. So the judges don't clearly the judges don't have time to sit there and read them. Yeah. They've got they've got their law clerks who are engaged looking at the substantive legal issues. The law clerks really don't have time to review a 500-page final fee application. The U.S. trustee has no time. And because it's gotten to be sort of like people pointing at each other, particularly with the U.S. trustee for years having been the primary watchdog of fee apps. Yeah. Well, they're now overburdened and now they have reduced staff. So I think there's less focus on fee applications than there used to be.
Which just means more ka-ching out the door.
Yeah, at higher cost.
Higher cost.
Because if there's no break on the process.
It is what it is.
Yeah.
So now let's have some fun.
Sure.
cases that have gone sideways, cases that you wish you hadn't taken, cases that are personalities who shall remain nameless that you knew once and that you're glad you don't know anymore. I'll start.
Okay.
You remember when we were in El Paso?
Yeah.
And there was a hearing before Judge Clark in the El Paso refinery case. And I don't remember what it was on. I don't remember if it was cash collateral or DIP or whatever, but there was a group of lawyers who came down from New York. And there was one of those lawyers who was an older guy. I know you're rolling your eyes because you know exactly what I'm talking about.
Yeah.
Who was their former bankruptcy judge.
Yeah.
And so we're all sitting there because I'm the financial advisor and to the trustee. And this guy starts lecturing Judge Clark on the law and on the merits. And I could remember watching Judge Clark's face quickly turn red and then turn to stone. And I was looking for a place to quietly crawl under one of the tables so I didn't get, splattered by the blood and the gore that was getting ready to happen. So that's one of my notable stories. How about you?
Well, in the same case, I had to argue against that former judge, and I very often found myself
I know who you're talking about.
biting my tongue and deciding, regardless of what he said, I was winning as long as he was talking. And he scored no points with that judge and had such sort of an abrasive manner about him.
Yeah.
Not to mention the fact he was about 50% wrong in the law, that he kind of did our work for him. The El Paso refinery case, very interesting case.
It was.
It started out as an 11, had some problems during the 11, quickly converted to a chapter. Well, quickly got one of the peculiarities about it was the bankruptcy court, as you recall, appointed an examiner with expanded powers, who, among other things, sold the refinery as an examiner. And then with what was left over, which was the chain of gas station stores that I think you sold, and a lot of other assets and a lot of other liabilities, converted the case. A trustee was appointed to what was probably the largest Chapter 7 in the country at the time. I got hired as trustee's general counsel. You were the financial advisor for the trustee. And what was so fascinating about that case was, in addition to having the operating assets in the gas station subsidiary, I guess it's still in part of the refinery, which we ended up selling to Chevron.
Right.
And I remember you driving a fire truck we sold.
They had sold, the examiner had sold a bunch of assets.
Yeah, but not all of them.
But not all of them.
Right.
And they sold them to Chevron. And I don't remember if it was non-commercial values or what it was. But the Chapter 7 trustee decided, well, wait a minute, I don't think this is right because they have more value. And Kemp Smith was involved at some point. I don't remember who Larry was representing.
Yeah.
But so they overturned the order. And I literally went and picked up an asset that had been sold to Chevron, went on their lot, got in the cab of a fire truck and drove it away.
Yeah, I didn't recall. I remember you driving the fire truck.
And drove it to the Chapter 7 trustee's office and turned all the lights on and said, now what do you want me to do with it?
So the examiner actually lifted the stay for the lenders on the main refinery. And that refinery was put by the lenders, because they're not in the business of running refineries, into a special purpose vehicle that they all own. The various lenders owned a piece of. And what was so interesting is a former refinery employee who went to work for the SPV ended up buying it for very little money, because I think they were losing money at the time. And that became Western Refining, and which parlayed through mergers and acquisition. And I think he's now one of the more significant shareholders in Valero.
Yeah.
So fascinating story. Really interesting environmental claims arising out of the refinery. We had a conflict on that, so the local firm picked that up, did a terrific job with it. Really interesting case for a lot of reasons.
And they don't always turn out how you think they're going to.
No.
I mean, it's people think that, just because you're a professional involved in the case, you know exactly what's going to happen and how it's going to happen and can plan that out. And lots of times I found, and I know you have too, you think you're going down one path, and before you know it, you've taken a sideway track to the right, and you're 100 yards, down the roadway before you get a chance to say, well, wait a minute, why are we doing this?
Right. And the other thing that you've seen in this business is that you end up becoming an expert in each new client's business.
Yeah.
So, you mentioned airlines. So there's a bunch of airline cases, railroad tank cars, railroad leasing companies, Blue Water. I filed a Blue Water shipping company, Chapter 11 in New York, offshore rig cases, retail stores, restaurants. Part of the fun of being a bankruptcy lawyer is you get to see so many different industries, and it's not just a drive-by because you actually have to develop some level of expertise in all those businesses.
Well, that's why I'm still doing this after all this time, is because it is interesting. You never know, what business you're going to get involved in as a chief restructuring officer or a interim CEO, like that publicly traded cannabis company where I became the interim CEO and chairman of the board. That was very interesting.
Yeah.
Some of the problems there, including having to get licensed in various states. And what's interesting to me as well is how, and this goes back to the chapter 22s, you can work hard. And you're in a hard business, I'm in a hard business, long hours, can be lots of travel, sometimes not so grateful clients, and certainly creditor constituencies, which maybe we're not that crazy about you. But you work really hard to get a result that you think is reasonable. And you say, thank you very much. And you pick up your last check. And 18 months or 2 years later, they've taken all that work that you've done,
well,
and it's all tanked again. And they're either, back in another Chapter 11 or liquidated or going out of business. And you sit there and go, so I just spent 2 years of my life, doing this, and you guys just tanked it. How does that work?
Well, it's recurring business.
That's exactly right.
The one thing
that's what Sharon, my wife, always says to me when I'm bitching and moaning about it. She says, "Listen, if people out there weren't doing stupid things in business, you wouldn't have a job. So you just need to sit down and cut it out."
Yeah, but both you and I have made lifelong friends through people that with people that we were at their throat of in the last case.
Yeah.
And, so
it's true.
You get to work with really smart, really interesting people, very often under stress, but that's a good way to form bonds. You probably ought to spend a few minutes, you think, talking about kind of where we go from here.
Oh yeah, I'd love to. That's a great idea.
I think in getting ready for this, I did, just a little bit of brushing up on the changes, the statutory changes, transfer from the act to the.
You mean you actually prepared for something, John?
Code.
I'm shocked.
You're shocked. I know. Yeah. Not that I've ever done that before. You look at, there's an old adage. I think it's in the. I think it may be in the book of Genesis. There's nothing new under the sun.
Exactly.
What has been will be again. What was done before will be done again. There's nothing new under the sun. To a certain extent, the trends that I see in bankruptcy, if you go back historically, are sort of repeats of what happened in the 30s and 40s. So does that mean we're in for another wholesale set of legislative changes? Given how Congress is right now, I don't think so. But there may be some that are afoot. I went to a conference in New Orleans, and one of the speakers was preeminent bankruptcy lawyer, now doing other things, Jamie Sprayregan.
Oh, sure.
And Jamie talked about the last Bankruptcy Review Commission and the study that they put together and sent to Congress. I think he said they worked on it hard for 18 months. It got sent to, I think, the Judiciary Committee or one of the committees. And he said, we never heard peep. I think it got, went to file 13 which is sort of frustrating for everybody because I saw a draft of the report, and there were a lot of people spent a lot of time, very thoughtful people, judges, practitioners, bankers, professors. So it usually takes something like an Enron or WorldCom case to end up requiring statutory changes. We may have some of that right now with regard to venue and disclosure and things of that nature. I don't think it's gotten to that point yet, but it's a building process, and we're about due for another Enron type debacle that causes some wholesale change.
But until then, it's a little bit like Pirates of the Caribbean, follow the code. And the code is kind of it's more of a suggestion.
Yeah. Well, you talk about the differences. When you and I first started, there wasn't much in the way of precedent.
No, there wasn't. It was like everything was brand new.
Yeah. So, the judges, the practitioners, there was a certain element of we're all in this together and we're kind of making it up as we go along, but we're trying to do the right thing.
Right.
Now
right.
Now you've got much more precedent. And so there is still a lot of creative work that goes on, but I don't know that it is as wide ranging as it used to be.
I think that's right.
Yeah.
Well, finally, so you and I threw away our crystal balls decades ago. What do you think the next cycle looks like? Everybody is curious about, are there going to be more bankruptcies, less bankruptcies, more business failures, less business failures? What are your gurus and you and your firm thinking about that?
Look, we read the same tea leaves and reports that everyone else does. With interest rates remain high, until the Fed backs off, I think we're going to continue to see failures. There are industries that are import dependent that are hard hit. We're involved in the Morelli automotive company that just filed recently. Those kinds of companies are going to continue to be stressed because they've got tariff issues, interest rate issues, consumer issues, a lot. So I think for the shorter term, we're going to see companies that are dependent on foreign imports, renewable energy, filing, may see some more fallout in retail and fast casual food dining.
Right.
It's going to be real interesting in the oil and oil field services case.
I agree with you about that.
Because prices, I check every morning, prices are up again today for West Texas Intermediate, the benchmark crude oil.
Because of the
Iranian stuff.
The Iranian stuff.
Right. So God knows what's going to happen there.
Yeah.
That could cause a major disruption. And, God willing, if peace breaks out suddenly, there's going to be a dramatic drop in oil prices that will typically hit the oil field service companies first, and then will migrate to the less well-capitalized oil and gas companies. I don't think we're going to see like a 2008 style crash again, but we may have some dislocation there, or that may be the hot market. It just depends what happens over there.
Yeah, I think that's the thing that has struck me over the years is that it's not even the crystal ball. The dynamics are so much different, and they're so fast, and they're so much greater than they appeared to be when we were first starting, that it's changed the game.
Yeah, Drew, I think a lot of that was, given where we were in our careers, we were probably so busy keeping our noses to the grindstone that
You're probably right.
We weren't looking at the horizon. We were looking at what was immediately in front of us.
Yeah, I think that's right.
Because nobody really cared what the 25-year-old Drew McManigal or John Melko thought about anything.
Well, if they'd listened to us, they would have been much better off.
Well, that's true. That's true.
And on that note.
Oh, very good. Well, Drew, it's been a pleasure.
Listen, thanks for being my first
You
guest. I appreciate it.
It's fine. Thanks.
You're welcome.